There we go. I'll go ahead and call to order this hearing of August 22nd, 2024 in the matter of appeal of Z0164-24, appeal of a Measure 49 petition. My name is Joe Turner. I'm the county's hearings officer. I'll start with some brief announcements and a summary of the process that will follow so everyone understands how you can participate in the hearing today. I start by saying I'm not a county employee. I'm licensed as an attorney and trained as a planner. I serve under contract to the Board of Commissioners. I say that so you know you're getting an independent review of the application before me today. My role as the hearings officer is to conduct the hearings and in making my decisions, I am required to apply the county's existing laws. I am not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Planning Commission and Board of Commissioners to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. As a hearings officer, I'm to provide an unbiased decision maker, and I believe I am unbiased with regard to the application the appeal before me today. I have not had any pre-hearing contact with any of the parties regarding the substance of the application or appeal, and I don't have any interest in the subject property or any of the surrounding properties. But you have the right to challenge my impartiality, to argue that I'm biased in one way or another, and you can do that when it's your opportunity to testify. Procedure will follow. I'll start by asking staff to summarize their staff report and respond to the appeal. Then the applicant will have the opportunity to testify, present their proposal, and respond to the appeal. Then, I will give the appellants the opportunity to present their appeals. Then I will open it to the public testimony in support, in opposition, or with questions or concerns. So anybody who wants to testify will fall into one of those categories: the applicant, the appellants, or interested parties who are supporting, opposing, or have questions. Once everyone's had an initial opportunity to testify, I will give staff and the applicant alone an opportunity to respond to the testimony that was offered. If those responses include any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing and announce what I'm going to do. Generally, I will issue a final written decision within about 2 weeks after the close of the public record. I'll send my decision to the county. The county will send it on to parties of record. So anybody who testifies orally or in writing before the close of the record will be sure and receive a copy of my decision when it's issued. If you decide you don't need to testify but want to receive a copy of my decision, you can contact staff and they will send it to you as well. Anyone with an interest in this application may offer relevant oral or written testimony, but testimony must be relevant to the applicable approval criteria, which are set out in the staff report. Also, please don't speak unless you've been identified for that purpose. It's one person at a time testifying. Also, it's important that all parties make their best case to me. My decisions are final for purposes of the county, but may be appealed to the Land Use Board of Appeals, or LUBA. However, LUBA generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this application, you need to make sure it gets into the record before me. In order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me. If you feel you need more time to prepare, you can ask me to hold the record open or continue the hearing. If I hold the record open, you'll have an opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we can come back and do this again at a later date. But whether or not the hearing is continued or the record is held open for any other purpose, state law requires that I hold the record open for an additional week for the applicant alone to submit a final written argument without any new evidence. The applicant can waive that right if they choose, but if anybody else wants me to hold the record open or continue the hearing for any other purpose, you must make that request before the close of the hearing today. Also, my decision must comply with state law that requires that I issue a final written decision within 150 days after the application was filed. So there's some limit to how long I can hold the record open or continue the hearing. When you testify, please begin by stating your name and your full mailing address. If your full name is not listed on the screen, please spell your last name so I get it right. And if you represent someone else, please say so. Te Also, testimony should be relevant to the applicable approval criteria, which are set out in the staff report. And please don't repeat testimony offered by yourself or earlier witnesses. Repeating your testimony doesn't make your case any stronger. This is not a popularity contest. Whether everybody loves it or everybody hates it is not an issue I get to consider. The only issue before me is whether the application does or does not comply with the applicable approval criteria. There are a number of people who are online now, so if somebody has already said what you want to say, but you want to preserve your right to appeal, you can indicate that you want to testify, give us your name and address, say, I agree with the prior issues, and that's good enough to preserve your right to appeal. That concludes my introduction. Staff will go over the technical issues of the Zoom process.
Thanks, Joe. I'm just going to do a little introduction and go over the kind of procedure for the hearing. This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearings, which include the hearings officer, county staff, the two appellants and the representative, and the applicant, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording to the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. Attendees on a PC or iPad, you have a raise hand button in the Zoom bar at the top or bottom depending on your device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all the participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. Be sure to provide your name and mailing address when you begin. Once you have provided your testimony, your mic will be muted and your screen will return to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, email written testimony to myself, ldance@clackamas.us, or mail it to Clackamas County Planning and Zoning Division 150 Beaver Creek Road, Oregon City, Oregon 97045. And this information will be posted on the screen at several times as well. The staff contact email address is also available on the webpage where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the end of the day the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address by emailing the staff contact of the application or by entering it in the Zoom chat function during the hearing. Okay, that's everything.
Okay, go ahead and you want to summarize the staff decision and respond to appeal?
Okay, and I have a PowerPoint. Sure. Okay. I'm Lizbeth Dance, Clackamas County Planner. We're here today discussing the appeal of land use decision Z0164-24 for a 3-parcel Measure 49 partition. The applicant is Walter Eager. The two appellants of this decision are Ben and Sandra Bowl and William and Lori Rumsey, represented by Ty Wyman. So I wanted to give a brief overview of the application and what we're looking at today. This property is in the exclusive farm use zone. It is one legal lot of record known as tax lot 801. It is at the end of Roberts Road. It's in the exclusive farm use zone. It's approximately 6.44 acres. Measure 49 land divisions are allowed by state law as adopted by the claim. Measure 49 claims do two things. They circumvent the lot sizing standards of the zone, and they allow residential development in the zone where typically a vacant lot of property in the FU zone doesn't allow it. So Measure 49 claims, as established and still active, allow for residential development and land division of properties. This claim is valid and still owned by the original claimant. The Measure 49 claim E130513, which replaced original Measure 37 claim in 2006, has been public record and was issued July 29th, 2009. The application as provided complies with all approval standards as proposed or can comply with conditions of approval as required by the claim and Clackamas County Zoning and Development Ordinance. This is a rural land use review subject to a 150-day clock. For record information, the 150 day of this application is October 10th, 2024. 2 appeals were received. Additional comments letter were provided through the review of this application. I'm going to go through the appeal issues outlined in the appeal letters and address criteria in the zoning code that have been addressed in the land use decision, in the supplemental information provided, in the reports provided, and then in the additional response to appeal items and the exhibit list provided to the hearings officer and open to the public up until today's hearing. First issue brought up was that the Measure 49 claim requires that parcels be clustered with a remainder tract. This property in its configuration is clearly clustered. The 2 smaller parcels are adjacent to each other or grouped together, which is the definition of a cluster, with the remainder larger lot 3 at the back or south of the property. So meeting the standard of the Measure 49 claim, the 2 smaller lots that cannot be larger than 2 acres are clustered along the north with the larger property to the south. The appellant brought up question of the property's owner of the property being owned by the claimant. The deed was provided with the submittal packet, Exhibit 2, pages 29 through 33, clearly identifying that Walter Eager owns 100% of parcel 801, which is Exhibit 3. And then this is just a screenshot of the assessor's record showing the percentage and the taxpayer. And then furthermore, the Eggers owned tax lot 800 and 801. In 1995, they applied for a non-farm dwelling land use decision to separate out lot 800 and also to allow for a home to be built on that lot as a non-farm dwelling. This lot was legally created and tax lot 801 is a legal lot of record. The appellant provided information about with an easement, and they've, in their most recent document submitted last night around 5 o'clock, addressed that document did not address this property. I just wanted to make that quick statement. It seems like they corrected that statement as well. The appellant brought up issues with trees and wooded areas and significant clumps of trees. Properties in the resource zones, their primary allowed uses are farming and agricultural uses. Significant tree clumps are not necessarily considered in resource zones. In addition, the trees on this property were planted by the property owner in 1999, and similar to the idea of being planted as a Christmas tree farm. The partition approves the criteria for 3 parcels with satisfied availability for water, septic, and access. Prior to plat recording, only access to each parcel is required to be established. Future development outside of Measure 49 allowances and EFU zone allowed uses are not reviewed or approved with a partition. Here's some aerial imaging showing the property in 2006, 2012, and 2023. There are no significant trees on this property. Though they are old and substantial, they are not considered significant or considered significant by the Zoning and Development Ordinance.
How does the code define significant tree?
It doesn't, it's a very loose definition, but in the resource zones, significant trees are trees that have standings that provide additional shading and characteristics for surrounding properties or the property itself and could be considered a heritage tree. Heritage trees are typically trees that are over 200 years old.
Is that in the code?
No, it's not in the code. It doesn't
Okay.
go into that level of detail. That's
Okay.
just from like county assessment that we've seen typically. And we don't protect the heritage trees any longer in our zoning code either. And I can review that more and get back to you with more detail. There was questions about fire hazards and fire hazard areas as outlined in 1003 of the zoning code. Land divisions, this doesn't have a fire hazard overlay. This property is not within a fire hazard overlay. It is understood that fires are definitely an increasing area of significance in this county, the state, and the country. But the fire hazards are not addressed in the zoning code because there's no fire hazard overlay on the property. However, through a land division, partitions are required to address access, water availability, and to be approved by a local fire district prior to plat recording, and again prior to residential development, not reviewed with the partition. As part and parcel of a partition, these standards are met. Tualatin Valley Fire Rescue comments provide and added to the record Exhibit 6 address that this development of a 3-lot partition can meet the standards required by the fire department to have homes that are adequately maintained and provide fire safety. The property is within the Sherwood-Wilsonville groundwater limited area. All standards that apply to land divisions in the county have been applied as outlined. This property is in the groundwater limited area. The applicant for the land division in these areas is subject to additional standards outlined and required to be assessed through a hydrogeologic assessment prepared by a licensed professional. County staff admittedly is not a hydrogeologist qualified to assess this information. Peer review is also required of these reports done by a licensed professional. This review assesses if water is available as outlined in Z0164-24. The applicant provided this report, Exhibit 2A, prepared by HGX Solutions. A peer review was conducted of this report by GSI Water Solutions, and these certified hydrologists determined that the addition of 2 home sites, one allowed outright, would not create a significant draw on the aquifer. The appeal letter provides additional well deepening and development not substantiated by any available data and outside of the required 1 corridor mile assessment area. Michael Higgins of HGX Solutions, with no verified evidence of these statements, assessed the initial hydrogeologic assessment with these additional items of the drawdown and the additional wells being created, and determined that the 3-lot partition, the addition of 2 home sites, could still be allowed and meets the standards outlined in the zoning and development note in the ZDO, showing no significant draws to the aquifer. So the property in relation to groundwater limited areas and the assumed draws, assumed assessment area, and impact of the groundwater has been determined that this property could support and would not create a negative impact on the aquifer in the area. There was several comments around transportation engineering conditions for roads and road safety and life safety. Johnny Gish with Transportation Engineering is here. He provided additional comments, kind of clarifying some of the statements provided in the original land use decision. His comments that were provided with the original land decision are an exhibit in the exhibit records, as well as being adopted into the staff decision as conditions of approval. Some base clarification questions that I just wanted kind of to address is one of the statements was that the site distance is a requirement for pulling in and out of a driveway. In the site distance requirements, it's required that the property owner do clearing to allow for clear vision standards. It is understood that the width of the road is not the entire width of the right-of-way, and the applicant, as they're preparing to meet standards outlined in the land use decision, can do clearing within the right-of-way, not on private property. There is not a condition that requires any work that is not within a right-of-way or on property owned by the applicant. That is not a condition of approval or something that the county would ever require. Required site distance standards are assessed for land. Access easement and emergency services standards, Tualatin Valley Fire and Rescue is required to do initial review of the access roads and is required to be developed prior to recording as outlined in Exhibit 6. And the 30-foot access flagpole and site area can be made sufficient prior to plat recording and again prior to residential development for Tualatin Valley Fire and Rescue to ensure protection of the public health and safety. Johnny Gish with Transportation Engineering is here. He also provided comments in response to the appeal. And Johnny, I didn't know if you wanted to add anything at this time. I do have your photos that you took from the site as a slide if you wanted to say anything at this time.
No, the only thing that I would add is while vegetation is required to be maintained by the adjacent
Mr. Gish, can we get your name and title?
Johnny Gish, Clackamas County Engineering. The vegetation is required to be maintained by the adjacent property owner within the right-of-way and also outside of the right-of-way on private property itself, and that's within the Clackamas County Code, Chapter 703 underneath road use. So vegetation can be required to be cleared through code enforcement requirements and adjacent to also just, you know, required along the roadway from adjacent property owners as well, within the right of way only, not on private property.
Thanks, John.
I'm sorry, that last part, I thought you said they could clear on private property, then you said they can't. Can you clarify that?
No. You cannot clear vegetation on private property without permission of the property owner.
Okay. Then you said something about code enforcement before that.
So Clackamas County Code Chapter 7.03 road use does require property owners to maintain vegetation on their own private property in response to code violations of overgrown vegetation. And that's something that transportation engineering will reach out to adjacent property owners when there's a complaint. But in response to private property vegetation, that's how it's addressed.
So that would be in reference to the intersection to the west, not the site access, but the public road intersections.
Adjacent to any intersections or along county roads.
Including private driveways?
That does include private driveways as well.
Okay.
So anything along the county road. So if it's
all
along a private road, no, we don't have any jurisdiction on private roads, but along the county right of way, yes. So at the intersection of Lad Hill and Roberts Road, that would be applicable. County code would be applicable there. Along the private road of the subject development here, that would not be the case.
Okay, that's what I thought.
It would be the case.
And then just flagpole lots, when they're created, usually have a 20 or 30-foot wide pole. And then the road surface within that pole as required is there's a drive surface and then an easement width. And then those widths change when you go from 3 to 2 home sites. And so for this property as a 3-lot partition, you'd have a 25-foot easement driveway width until the driveway pulled off for the first home site. And then that would be reduced to 20 and 12 for the next home sites. In sites that have these flagpole configurations, typically there can be a fire truck turnout. Fire truck turnouts only need 25 feet of full roadway width. And then at the end, there would be a turnaround or a hammerhead of some sort to allow a fire truck to turn around at the end of the road and come back out. Those road designs, as far as prior to plat recording, the property owner is responsible for building access to all lots created prior to a plat is recorded, subject to the standards of the roadway, subject to the roadway standards. The zoning and development ordinance is not the roadway standards. ZDO section 1007 requires development to meet those standards as as best they can, but we do not enforce the roadway standards outside of 1007 of the zoning code. Roadway standards are required to be implemented and established as required by the Transportation Engineering Department prior to plat recording. And so the standards for fire and life safety for access to this property and the building of the driveway will be completed prior to a land division recording. This concludes the staff presentation. I did want to state that yesterday at 4:55, Ty Wyman and the appellants provided additional documents. Those were added to the exhibit list as exhibits 11, A, B, and C. I was able to review them a little bit before today's hearings. They mostly address roadway and safety issues as far as roadway standards are concerned. And then the adjacent property owners provided additional photos of the access and the turnout and the roadway, and those are in exhibits. If you haven't had a chance to look at them, we can look at them together at any time. I just wanted to kind of address those things.
I did review them yesterday. The photos from the neighbors, is that exhibit 12? Just
no, exhibit 12 is I'll get to that.
okay.
Yeah.
Is the neighbors photos just included 11A
It's
through
exhibit
C?
11C are the neighbors' photos.
Okay.
Yep.
Just wanted to check.
Yep. And then upon review of staff's decisions, I found some typos. And so as just opportunity to correct errors that I have made, I did correct some of those typos. One of them was calling out properties 1 and 2 or 2 and 3 not consistently through the decision, so I corrected that. The naming of Roberts and Roberts Road, Roberts Avenue, and Robert Road is now consistent throughout the decision. Tualatin Valley Fire and Rescue provided comments in response to this application during between appeal hearing being scheduled and notice and our hearing today. Typically, I take transportation engineering comments and add them as advisory notes in a staff decision. And so I included the reference to the Tualatin Valley Fire Rescue comments to be added as advisory notes in the decision. That's what is Exhibit 12. It's just my kind of corrected, edited staff decision. I would appreciate it if we could use the one without the typos, if possible.
Okay. Appreciate that.
Yeah, and then that concludes the hearing or the presentation of staff supporting of this land use decision.
Okay. Can you go to the site plan? It looks like page 4, that one.
Yeah.
It shows a septic drain field for all the properties on lot 3, the southern lot. Right. It's my understanding they are required to provide septic drain fields, individual ones on each lot. Is that correct?
Yeah, they have 3 septic approvals, and it's a condition in the decision. The septic approvals are called out in the land use decision specifically, and then septic approvals are identified as on each lot. Septic signed off on the submittal in the completeness view and identified that the lot lines and the septic locations were suitable. Those things are kind of sleuthed out through the draft recording documents prior to recording, and so they'll show the septic locations, the septic setbacks. But as it sits currently, there are 3 septic approvals on this property. As listed, let me go to the land use decision. I had it open. I forget where it is in the decision. It's in the land use decision. Hold on just a minute.
Okay. That's what I understood. I just wanted to make sure that was raised as an issue.
Yeah.
On page 7, condition 3F of your decision, it says on the final plat, a plat note required stating no water service is available. Should that be public water service?
Yes. Yeah, I will correct that.
And it says individual like wells to provide water. I assume that's what they're going to use, is individual exempt wells will provide water.
Yep, that's what you do. The hydrogeo assessment determines that water is available with the usage outlined in 1006-03 at the ratios, and there won't be a down draw. And then once that is determined, individual examples are allowed. They do have to go into the certain aquifer outlined in the decision, and so there's a requirement that they go. But that is the only aquifer there, but they do have to go into that aquifer.
Okay. And then on page 13, under paragraph D, the finding under paragraph D says, 3rd line, this access will be serving more than 3 properties, the flagpole. How is it more than 3 properties?
Oh, I think that was supposed to be no more than. Sorry, I will correct that as well.
Okay, it's just 3 properties.
Yeah, it's just 3 properties total. Yeah, and then to
Okay.
just something as note, the Measure 49 claim allows residential development. This lot as one lot of record currently could have 1 home built on it. Permits could come in for that. There would be nothing that would stop 1 home from being built today. The Measure 49 claim allows 2 additional homes. The only way to get additional homes on a property is through a land division. And so the land division is kind of part and parcel required in the Measure 49 claim.
Okay, that was the only questions I had at this point. Thank you.
Okay.
The applicant's opportunity to testify.
Okay. And Darcy, can you turn off my screen share for me again? Thank you.
It's the applicant. Can you hear me?
Yep.
Okay.
Can I get your name, sir?
Yes, it's Walter James Eager is my full name. And I live at 3500 Northwest Glenridge Place, Corvallis, Oregon, 97330. And in the process of submitting the application and in responding to the testimony of the appellant, I've covered this situation comprehensively and completely from my point of view, and I don't have any testimony to add at this particular point in time.
Thank you, sir. Now it's the appellant's opportunity to testify. Mr. Wyman or the Bose, I think is my friend pronouncing that right. Who wants to go first?
I am happy to.
Bull, I think you're muted.
Yeah,
I am
Mr. and Mrs. Bull, you're muted.
I am
Mr.
happy to
Wyman?
do. I'm
Okay.
happy to do
Okay.
so, Mr. Hearings Officer. But you
Mr.
could
Thank you, Mr.
Rumsey has
Wyman.
had his hand up.
you could flip a coin.
Mr. Rumsey has
Okay.
had his hand up.
Oh, thank you.
I had sent a chat message as well about the audience does not they're not able to testify, it appears.
They will be
They
able
will
to
be
testify when the time
Right.
comes.
So
I will allow them in. So
okay, I'm trying to tell them that in an email message.
They just heard me.
Oh,
Okay.
yeah. Okay, good. All right, thanks. Okay.
Mr. and Mrs. Bull, do you want Mr. Wyman to go first?
I can go if you wish.
Whoever wants to go first. It's up to you, the three of you.
I'm going.
Okay.
We have nothing further.
Can I get your names?
Oh, I'm sorry. Yeah, Ben Bull, 15500 Southwest Roberts Road, Sherwood.
Okay, go ahead.
97140. We have nothing further to add to the process at this time.
Okay, thank you. Mr. Wyman. And Mr. Wyman, in your written statement, you noted that it's 3 minutes. There is no, I don't impose time limits generally. So I have a number of questions just to clarify, and I don't want to take up your time. So as long as it's relevant, I will allow you to testify. Anyone to testify.
And I very much appreciate that, Mr. Hearings Officer, and appreciate your questions very much. That was one of the points that I was going to make, is that questions, we can't be responsive to you if you don't ask us, your questions. So we very much appreciate that. My name is correctly spelled here, Ty, T-Y-W-Y-M-A-N, and my address, mailing address is of record.
And you're representing the...
excuse me, yes. I'm representing Bill and Lori Rumsey, who
thank you.
are one of the appellants.
And, okay, I had to get Ms. Rumsey's first name spelling right because I had a couple options, but I saw it on my screen. Thank you. Go ahead, Mr. Wyman.
And maybe as I start, maybe I should ask, I have asked Bill and Lori to testify in their own rights. Again, I appreciate your admonition of keep it relevant, and I promise that I will do that. But if my clients could testify individually after me, I'd appreciate that. Okay. Yep. Okay, I was going to say, so as I look at the record before you here on August 22nd, I find it to be pretty robust and a lot a good bit of information has come in, seemingly just even within the last 24 hours. And I know I contributed quite a bit of that. So I'm going to leave continuance to your discretion. If you believe at the end of this that you would benefit by having people out here to testify again. But at a minimum, I definitely will ask for the record to be held open, just because, as I'm going to say here in a bit, the devil in these types of applications is just in the details. And I want us to be very detailed about what intersections we're looking at and what perspectives that we're taking on them. So I make my request for at a minimum, the record to be held open. And maybe, I don't know if 14 days is preclusive. I know 7, 7, and 7 is the standard, but in fact, I guess we don't have Labor Day coming up, but nonetheless, 14 days I think might help to get all of the information that addresses what was discussed today. So we have, this application is a vestige of Measure 49, and I certainly am not going to argue with the hearings officer the wisdom of the policy of Measure 49, but we are left, you and I and everyone participating here, to, as it will, clean up the details, and the devil is in those details. And if I could stress one thing to you today, it's Measure 49 does not constitute a golden ticket. It does not simply entitle 3 home sites. It's 3 home sites on condition that X, Y, and Z. Those X, Y, and Z, primarily from our perspective, are still health and safety standards. The county staff does not articulate it as such, but I believe county staff, in reading their decision, I get the idea that they understand that health and safety regulations must still be administered through this process. So the question is how that is done. I start with not easily. Again, this is still a rural area. It's still EFU. This was never planned, never designed. These roads were never designed for partition for home sites on acreage this small. And so we are still the county is left to shoehorn in development like this, particularly vis-a-vis the groundwater and vis-a-vis these intersections to rural roads. The critical part of my perspective on this, and one that I hope you will share, is the feasibility requirement. I believe that we are in it. I recall first seeing it back in the early 90s. People would always cite to the Rhine case, Rhine versus Multnomah County, basically said if you've got a 2-step approval process, tentative plat, final plat, it is fine in the first step of the approval process to leave some engineering, what I'm going to call engineering details, to a second step. But a jurisdiction can only do that if, one, it can make a determination that compliance is feasible, a present determination that is feasible to comply, and 2, because you're in effect pushing determination of compliance with discretionary criteria off to a later decision. You have to provide public notice and opportunity to comment in ironing out those details and making those decisions. In any case, probably, and certainly in a land use case, when you've got many criteria in play, you want to focus the hearings officer's attention on sort of the main one. And what strikes me in the main here is the intersection site distance at Lad Hill Road. And I'm going to go ahead and characterize for you now what I understand the sum and substance of the testimony to be. I do want to go back and look at the specifics of this testimony, particularly now we've got a new statement from the county engineer. I want to look at that, but what I'm understanding is, yes, at the Roberts Road, Lad Hill Road intersection, site distance requirement to the south is 390 feet. Within that site distance, we have private property, not only private property, but it's private property, the vegetation on which is subject to a restrictive covenant because it's in a what's been designated a scenic area. I believe that's a private designation. I don't know if it's a public one, but nonetheless, there is a covenant restricting removal of vegetation, as I understand it, on that property that is within. And the fact that the vegetation, the county staff is not trying to tell you that there is not vegetation within that 390-foot intersection site distance. Add to that, county staff in its written piece originally noted that there is also an embankment that is within that view corridor, I'll call it, intersection site distance. So you are asked to make a decision that it is feasible to cut, if it is feasible for this applicant to cut an embankment and remove vegetation on someone else's property in order to achieve intersection site distance. The reference to code enforcement mandating removal of vegetation on private land, to me, that just buttresses the infeasibility of this. I'm well aware, you're well aware that yes, if a bush on your property is growing out in front of the stop sign, it's your obligation to take care of it. But the notion that in order to ensure intersection site distance here, we're going to put this neighboring landowner through code enforcement. It just strikes me as we are past what is feasible, and that may be regrettable for the applicant. The applicant got the Measure 49 approval, but again, that does not necessarily say that you can develop if the infrastructure does not support it. And in this case, I believe that's what we have. Looking further at my notes, the one other element of this legally that I want to mention to you, there is testimony on the groundwater issue, and I believe you're going to hear quite a bit more testimony on the groundwater issue today. And I appreciate the county's recognition that the groundwater and sufficiency of groundwater is relevant here. We've got experts. I think at this point we're going to have experts on both sides, but we've got this dynamic that's not uncommon, I think, for you, of having experts who are viewing the issues, the groundwater issues, sort of from a desktop. They don't live there. They don't experience the groundwater. They're not tapping the actual wells that are near the property. So you've got sort of experts working from desktops, and I work from a desktop all the time. And I'm going to style myself an expert, but I accept that there's a lot of data out there. But I would urge you to listen to the folks who are really experiencing what's going on with the groundwater sufficiency here. And I would cite you to the case, I believe I thought I had marked it down here. I think it's Phillips versus Lane County, was a case in which LUBA accepted, look, yeah, you had sort of some very general expert testimony on the sufficiency, in that case, not of groundwater, it was the opposite. It was the sufficiency of septic, that the soils in question could suffice for septic service. And they said, but against that, you had this overwhelming amount of lay testimony from neighbors as to what was actually going on in their neighborhood on that issue. And so I'm asking you not to just simply defer to the folks who are hydrogeologists. That Mr. Herring's officer is all I had. I would accept your questions now, or if you want to listen to Bill and Lori and then pose questions.
Okay. It's just clarification of the exhibits in, yes. Trying to get this thing. Have I got it on a different screen? It's too big. You submitted a letter yesterday, Exhibit 11 now, 11A, and it had a number of attachments. One of which was a statement from your associate, Ms. Belak, which also appears to have some attachments. And so it's my understanding that her declaration, Ms. Belak's declaration, is attachment B of your letter. Is that correct?
I believe, and Ms. Belak is in the so-called audience here. I believe that I had her.
This is kind of a minor issue, and you could correct it during the open record, I think. I just want to give you the outline of where my confusion lies.
I know,
because
and Mr. Harry's officer, we went through this because we had them labeled as exhibits, and I said, well, the problem is that the county has a list of exhibits, and so then you get exhibits to exhibits, and it's confusing. But yes, I believe so. Ms. Belak prepared two declarations, one of which was to basically withdraw the deed that was submitted with the appeal, and that was simply bad data from a title company
I understand
website.
That's happened.
Well, and I do apologize.
I appreciate that. But then I think there's a deed attached to her. It appears to be attached to her statement that appears to be labeled as Exhibit A. And then on the document I got, the electronic document I got from the county, it says 11A 12. Okay, but never mind. I understand that. It's just the printing for the Exhibit 11 went over the top of the footer on that one. So that created, now I understand what's going on there. But my question is that you can address during the open record is that deed Exhibit A of her statement, which is Exhibit 2 or B of your letter. And then I think there was another attachment to hers. So I just want to clarify which one's which.
Yep.
And like you noted, the exhibit name, I tend to, if I'm referring to an attachment to a letter that's been labeled as an exhibit, I just refer to yours is Exhibit 11A. And anything that's attached to that, I refer to as an attachment in my decision. So I can address that confusion there. I just want to know which one's correct. Just want to correct the attachments to your letter, which one's which.
No, and I appreciate that. I appreciate that, and we will correct it during the open record period. I think that you might receive testimony. I'm not sure of all of the neighbors and whether they're sort of all here, but this pertains. One of her declarations pertained to a deed in the restrictive covenant on neighboring property, and you might hear. I suspect you will hear some testimony about what Ms. Belak declared there, but we will clarify what we were referring to in the open record period.
Appreciate
Thank
that.
you. Thank you.
And one more minor, just for the future, that may be the counties as well. Your letter came in as a 48-page PDF. If possible, could we submit those as separate files? So your letter would be Exhibit 11A1. Ms. Belak's attachment would be 11A B2, the road standards, et cetera. Just so they're smaller individual documents. I don't have to scroll through to find a particular attachment.
Yes.
I don't, this is something we're all getting used to with these electronic files.
Right.
Just wanted to throw it out there. So those are the only questions I had for you at this time, Mr. Wyman.
Excellent. And I appreciate you looking at my letter very much.
Yeah. So Mr. and Mrs. Bowes, or apologize, I don't have your names on my screen. But Bowl, sorry. There we go. You're unmuted. And you didn't want to testify at this point. Is that correct, Mr. Bull?
Well, I was going to testify later.
Okay.
Our biggest issue is traffic safety. I don't know if it's appropriate to make that statement at this time.
It is, but I just realized I forgot Mr. Wyman wanted his clients to testify as well. So if it's okay with you, I'll go ahead and take their testimony.
That's
So
fine.
Okay, thank you.
Just don't forget me.
Yeah, I won't. Mr. Rumsey, Mr. Rumsey.
Yes, that's correct.
you.
William Rumsey.
Thank you.
And before I begin, I've just received a text message from Mark Smith, who owns lot 700 next to lot 801 easement. And he wanted to testify, but he's got a doctor's appointment. So I'm wondering if his testimony can be admitted in written form. And
Sure, absolutely. I'm going to hold the record open because Mr. Wyman had requested that. So absolutely, he can submit it in writing, and I will.
Thank you for that. And there may be a number of others who have dropped off
Yeah.
the call because they got a bit frustrated.
Anybody can submit during the open record period. At the end of the hearing, I will outline the process for that and the deadlines for submittals. But
that would be grand. And I want to thank Darcy for her patience with all of us around the technical hookups. Having set up these meetings myself, I know it's not an easy task. So, Mr. Hearings Officer, my name is William Rumsey. I live at 15520 Southwest Roberts Road and have done so since 2016 when we purchased the property. My wife is Laurie, and I believe she would like to testify after I'm finished as well. Several years ago, Laurie and I fell in love with the Pacific Northwest, especially Oregon's rural areas. And we, as a result, we decided to make Oregon's wine country our retirement community. So after spending 4 years flying back and forth from the East Coast, we're originally from Pennsylvania, we found our forever property on Roberts Road, which contained a small vineyard that was surrounded by orchards, forests, and other vineyards, all placed on a 15-foot wide dead-end rural road, the subject of this morning's discussion, Roberts Road. When we first drove up Roberts Road, we felt as if we had just arrived on a movie set for the movie Fern Gully, with ferns growing out of moss attached to giant fir trees, lichen hanging from branches.
Mr. Rumsey, I appreciate there's a lot of background. If you could just cut to the issues.
Okay, so glad to do that. Just a point of record, though, is that our intention was to build a new home on an EFU lot. But our understanding at the time was that that was not possible unless that lot contained an existing structure. Okay. So we were either naive or misled. But nonetheless, when we found Roberts Road and saw the existing lands around it, including Lot 801, which was completely forested at the time, or nearly completely forested, we were under the impression that new construction could not occur. And
the law changed with Measure 49. I don't know if it was before or after you purchased. I don't recall exactly when.
Purchased in 16. So yeah, but we were still under the impression from several individuals at the time that that was not possible. So at that time, our expectation is that our forever home was going to be exactly as it was when we bought it. And as I said, we were a bit naive. We're also naive about the risks associated with Roberts Road. And those risks are 3. 1 is the fire hazard. 2 is traffic. 3 is the water availability. So facts regarding fire are very clear. That Oregon, of course, suffers from fires every year. In 2023, considered a mild year, there were over 1,700 fires in Oregon. In 2020, we were here, and the Labor Day fires brought about more than 2,000 fires, burning more than 1 million acres, destroying over 3,000 homes, and unfortunately killing 11 people. That year, 3 fires broke out within 2 miles of our home. And with the high winds, we were quickly put on evacuation level 1. Now, in addition to that, in the state of Oregon, our firefighters must respond to house fires. And strangely enough, or as it may sound, house fires in Oregon occur every 3 hours and 52 minutes, requiring firefighters to respond. Those fires are largely derived from cooking accidents. Now, as you may not know, Mr. Hearings Officer, the closest fire department house is 4.3 miles away in Sherwood. The second most closest one is in Tigard, which is 11 miles. The Trover property, which is lot 705, directly across from the access road, the easement of lot 801, contains a 10,000-gallon water tank. However, that water tank is over 900 feet from where these proposed houses will sit. Therefore, it's essential that firefighters have rapid access to the Roberts Rose homes, in addition, the homes to be developed by Mr. Ager. We have submitted expert evidence from HBH engineers that access to the proposed Roberts to Ager property by a fire truck, which are at the very least 30 feet long and weigh over 12,000 pounds, is not feasible unless considerable roadway changes occur, requiring building of embankments and the removal of several trees on the Trover property, as well as other earth-moving alterations on our vineyard property. In agreement with the county, we have submitted—
Did you submit that HBH engineers?
Yes, I have.
Okay.
It's part of our exhibits that were submitted, I believe, by Mr. Wyman's office yesterday.
Oh, okay.
We also have the engineer on the line, and he can testify today on my notification if we give him an opportunity.
I got the Mr. Wyman submittal late yesterday, so I may not have gotten to that point. So thank you. Just want to make sure it's in the record.
Sure.
Go ahead.
Secondly, as I noted, traffic safety. So as it exists, there are currently 8 residences fed by Roberts Road. Each of those residents has at least 2 cars. The proposal for 3 new homes would add at least 6 more cars, bringing the total number of cars to 22. During an emergency evacuation, this places a large safety burden on the hazards already identified by the county and others not described for Roberts Road. For example, there is an obstacle on Roberts Road directly in front of the Trovers property, lot 705. And 2 incidents have already occurred where cars have run off of Roberts Road and down its treacherous slopes, one of which includes Mr. Ager a number of years ago.
What is the I can't remember what you just called it on in front of the Trover property, the obstacle or whatever you called it.
The way the road bends, all right, the way it bends, and with the vegetation that exists, and it's a considerable bend, you have to creep up on that area very slowly. If somebody's coming in the opposite direction, you can't see them at all.
Okay, because of the curve of the road.
It's totally blind.
Okay.
All right. And that is around the area which Mr. Ager actually went off the road many years ago. The new homes, of course, and they're likely to have families with children that require school buses. They require deliveries from UPS, FedEx, Amazon, all of which increase the traffic safety risks that have been identified not only by the county, but the one that I added this morning. Now, lastly, we talk about the well water. And again, I'd like to address that just momentarily. Lot 801 proposal calls for 3 wells in series, beginning 150 feet from our existing well, which was placed in 1996. Although Mr. Higgins of HCX refutes poor water availability, many of his statistics are drawn from Marion County, not Clackamas, not Yamhill, on which Parrot Mountain and our neighbors sit. The Parrot Mountain study conducted in 1995, 96, and years thereafter indicated that well levels have declined 1 foot per year over a course of 14 years. In agreement with that study, our neighbors have described well problems, one of which is Farah Ramchandani's property, of which she has 2 wells. In the summer, the one well is completely dry, requiring the input of 3,000 gallons brought in by truck. And that is on Lad Hill Road, within less than 2 miles from my property by driving, not as the crow flies. The other well has water pressure problems, indicative of future well loss. Now, Mr. Higgins suggests that the low rate of well deepenings or replacements in his statement suggests that there's plenty of water availability. However, Mr. Higgins is not considering that our community is populated by a number of retirees on limited incomes. Well drilling is costly. A typical well of 400 feet costs over $30,000. So often people do not go about deepening their well or drilling a new well simply because of the costs. Moreover, we know that well deepenings in our area often could potentially result in saltwater contamination. I say this because of public record is the well driven on the Barker property on Roberts Road, which was placed in 2020 and had to go over 600 feet initially. And when doing so, it hit saltwater contamination.
And what was the name of that property owner?
Barker.
Thank you.
Okay,
yeah, I remember reading that, but I just want to make sure I got it in my note.
Right. So lastly, our neighborhood wells are old. They're not made with modern materials, modern casings, and therefore commingling is a potential problem, tapping into interflow zones and interference. And our engineer has attested in his letter that the implementation of 3 additional wells could constitute interference given the close proximity of those wells to ours. So in total, the span between our well and the 3 proposed wells is less than 1,000 feet.
The what is less than 1,000 feet?
The total distance between our well and the proposed 3 wells is less than 1,000 feet.
Yeah.
Much less. I'll end there and thank you again for the opportunity to testify. If you require my engineer's opinion, in addition to the written testimony, I'll be glad to text him and see if he can come online when Darcy allows further testimony.
Okay. If you want to call him as a witness, you certainly can. It's what you present is up to you. But was his testimony, his written statement submitted yesterday as well with Mr. Wayman?
Yes, it was, the entire package. So I think it's there. I don't know that anything further can be said, to be quite honest.
Okay. Thank you, sir. Thank you.
All right, so I'll stop there and allow Laurie to pick up.
Okay.
Thank you.
And Mr. Rumsey, if you'll mute yourself, and Ms. Rumsey, it looks like you are unmuted. Oh, you are. You've taken care of it already. Thank you. Go ahead, Ms. Rumsey.
Hi, I'm Laurie Rumsey. My address is 15520 Southwest Roberts Road in Sherwood, Oregon. I'll be brief because Bill has really expressed our concerns eloquently. I'm scared for the fire safety, for the traffic concerns, and for the water concerns. But we spend days in the summer watching for smoke, watching the local properties watching the weather and lightning strikes, because the fear of a fire where we are, where Tualatin Valley is not going to get to us quickly, and where if the trucks have to pump from our wells, they're not going to have enough water. So the fire safety is huge. The ability of the trucks to get to us up a narrow 15-foot road, us trying to get out with our families and our pets while trucks are trying to get in would be impossible. So we would either be trapped by the trucks on the hill, or they wouldn't be able to get up to us on the hill by the other people trying to get out. So that's a reality in our world, because there's no ability for two cars to pass on that road, let alone a car and a truck. And the second thing, when we talk about road safety on Roberts Road and the number of cars and the increasing number of cars, again, no two cars can go by, but more people driving up and down and at faster paces around semi-blind curves like the one that Bill described in front of the Trover's property, and then the drop-off on the side where there have in fact been workers go over and total their cars. And in addition, to possible teenage drivers, which we're going to have 3 in the next several years, from neighbors that live on the road, is really a fear for not only their health, safety, and welfare, but ours. Not that they're not lovely people, but we know what teenage drivers are like. And it's scary anticipating that in the future and adding more to that with 3 additional properties with children and buses, etc. So I'm here out of fear for everyone on our hill and our neighborhood, including any new families that would be added, because like us, they would come up naive and then find, hopefully not through accidents like fire and traffic accidents, that they could be really in peril. So that's really our fear.
Thank you, ma'am. You have your hand raised too. If you want to click on that, it'll go back down because you've obviously had a chance to testify. And if you'll mute yourself. Okay, back to the polls.
Really, our concern is traffic safety, and I would only estimate the statements that Bill Rumsey made, and I really don't have anything to add to that, except for the fact that we do have an orchard which requires shipping and receiving product and supplies, and frequently they're picked up with a semi or delivered with a semi. So, and there are people up here who do not back up well. So that really just accentuates the traffic problem. That's all I have to add.
Thank you, sir. Okay, now I'll open it to public testimony. Gotta get to the.
Can I just
yeah, go ahead.
Johnny Gish with engineering. I don't know if he had a kind of a timeline. I don't know if he left.
Okay.
Darcy, is he gone? Yes. So he's engineering staff who can really address all the traffic and life safety concerns. He did provide exhibit, but as far as concerns meeting roadway standards per the zoning and development ordinance and substantial development, there isn't anything beyond that. And Johnny was kind of my engineering person to kind of address that. The letter provided in comments yesterday does have engineered stamped assessment that addresses truck radius, turning radius, and then wells, but doesn't address any of the code criteria associated with those issues being met or not being met. If there's additional scientific evidence to be provided, that has not been provided at this time, but that is in exhibit 11C. It is on page 10.
Okay. Thank you. Now's the time for public testimony. Anybody who wants to testify at this point can click on the raise your hand button. Hand will appear and we'll call for names from that list. Right now I have Leanne Bennett with her hand raised.
Leanne Bennett.
Hi, my name is
Hi.
Leanne Bennett. I live at 16840 Southwest Parrot Mountain Road, Sherwood, Oregon. I'm also president of Friends of Parrot Mountain. I was involved in the 1995-1996 groundwater study that resulted in the Lad Hill Parrot Mountain groundwater limited area. The reason for that study at the time, and we went door to door to each individual neighbor asking about their wells, having their wells measured, was because there was a proposed 66 home sites on a forest farmland zoning. And that property was approved via a writ of mandamus because the county didn't respond in time. So the state water resources department enacted with that subdivision a limitation that if the neighboring wells were to drop, that subdivision was to cease use on their common wells. So since that time, the Oregon Water Resources Department has measured several wells in the area, not a lot, but they have, I think, 5 wells that they regularly measure. And we have seen significant water drops during that time. I think local testimony on what the wells are doing is going to be much more important than what you see in other neighboring counties. This property is in Clackamas County, but within a mile is Yamhill County and Washington County. So all those counties, all these properties in this mountain area are affected by the groundwater in the area. The other thing that I would like to mention is that on the plot map for this subdivision, the wells are placed 100 feet away from the proposed septic tanks. But it appears to me that those well locations are in the right-of-way of the setbacks, which are 20 feet from the roadway. And I don't know if that would be an approved location for a well head.
Yes, setbacks only apply to structures, above ground structures.
Okay, so isn't a wellhead an above ground structure?
They may be exempt, but it was something the applicant would have to address through the future approval process. They could, if necessary, move them elsewhere outside
Not necessarily, because they have that 100-foot radius from.
And it may also be possible to put it underground.
And there's a very limited size on those lots. So again, you've got health and safety involved in that.
That's something I'd like staff and the applicant to address, but the setback only applies to structured, but whether that's a structure or not is a good question.
Right. I would assume so, seeing many wellheads in my lifetime. Anyway, that's basically the issues that I'd like to discuss. But I think that the wells, the dropping of the wells, it is a severe concern in our area. And as you know, the Water Resources Department is very, very thin. So they don't do a lot of monitoring. But I think in the future, we're going to see water be, the most important issue there is. Thank you for your time.
Thank you. I have one question just real quick. Let me finish my note. Let me get back to that page. The 66 lot subdivision, what was the condition that was imposed?
If the neighboring wells that were pre-existing prior to that subdivision were to drop, that then they would have the right to have that 66-acre subdivision cease use on the wells that are supplying water to those homes.
Okay. And you said the Oregon Water Resources Department measured declines in water levels?
Yes.
Can you submit that
yes.
report or whatever was
yes.
documentation of that?
Yes.
And
That
to
would be great.
clarify, all that documentation should be in the groundwater assessment and peer review because that information is required to be part of the hydrogeo assessment provided with the application.
Okay.
And the other thing is, as you know, that several jurisdictions now receive their water from the Willamette River in Wilsonville, which is not that far from this property. So as these jurisdictions used to get their water from the wells in the area, and then
I understand that.
those wells really dropped. So at that point, and they were affecting wells in the rural areas. So that was what made the issue of having that water source come from the Willamette be a necessity. There are no other options for the area for water.
Yeah, I understand. Thank you, ma'am.
You bet.
Ms. Belak?
There we go. Can you hear me okay?
Yeah, you're a little bit soft though. Can you move closer to your mic?
Yeah, let me try that. Is that a little bit better?
A little bit. I'll just turn my volume up.
Okay. I'll try to use my big voice as well.
Thank you.
Mr. Hearings Officer, I just wanted to kind of bring some clarification to the filing. I do apologize.
Can I get I understand you work with Mr. Wyman. I assume the address is the same, but can you?
Yes, yeah. I'm sorry. My name is Maggie Belak. It should be spelled correctly on the screen. Address would be the same as Ty Wyman. Our office does represent the Rumseys in this appeal.
Okay, thank you. That's what I needed.
And then I just wanted to bring some clarification to the filings that were done yesterday. I did try to put a footer on all the pages just to help keep everything together. So the deed that you were asking about that was referenced in my declaration that was attachment B to Mr. Wyman's letter, that is the deed for the McDonald land that's referenced in the Kermit McDonald Trooper agreement.
I understood that. I just was confused about whether that's an attachment to yours or attachment to his.
It's a bit of like a Russian nesting egg doll situation. My declaration is an attachment to Mr. Wyman's letter, and then that is an exhibit to my declaration.
Does your declaration only have that one attachment?
It has 3 exhibits.
Okay, that's what I needed.
Okay.
There's 3. There's your letter or declaration, and then there's 3 additional documents that are attachments.
Correct. Yes.
Okay, that's what I needed.
Perfect. And then I believe Ms. Dan's already cleared up, but in the Rumsey declaration that I believe was 11I that was filed yesterday, that has the memo from HBH engineers in there.
Okay.
Any additional questions I can help to kind of clear up on the filing from yesterday?
Nope. Thank you. That was the primary issue.
Perfect. Thank you.
And Ms. Belak, can you click on the raise your hand button so you're, thank you. Is anybody, excuse me. Ms. Belak, your hand's raised again. Did you want to say something else? If not, okay. Is there anybody else who wants to say anything about this application? Paul Welty? Mr. Welty, you're muted. You'll need to unmute yourself. There we go.
Okay.
Turn my
yeah,
volume
thanks
back
for,
down. You're plenty loud.
Okay. I've been told that before. We live on I'm Paul Welty with my wife, Eve Stevenson. We live at 30700 Southwest Lad Hill Road, which is the first house on towards Sherwood past Roberts Road. Roberts Road runs up behind our property, and our concerns have been really well stated by Bill. We just want to bolster his concerns with fire. Traffic is a thing. The road just can't support that much traffic. And one of our concerns is if someone does drive off the road behind us, they're going to land in our backyard, possibly doing some damage. We certainly don't want that to happen. The water issues are of big concern to us. I think there's not much more we can say that hasn't been said. And the fire assessment is really a big thing as well that we have concerns with. And we appreciate Bill's assessment, and we support him completely in this. So that's where we're at.
Thank you, Mr. Welty. If you want to go ahead and click on the raise your hand button and mute yourself again.
Okay.
Is there Bev? I don't have a last name. You'll need to unmute yourself as well. There we go.
Yes, hello, my name is Beverly Trover, and I live at 16025 Southwest Roberts Road. I share all the concerns voiced so far regarding the well water, traffic, fire, and safety. I did want to mention when we first moved here in about 1995, Mr. Ager was driving up Roberts Road. It was a foggy night, and anyway, he missed the turn because the road curves by our house, and he drove over off the road down towards our driveway. So it's a drop off, and his car he mowed through a couple of trees we had planted. His car was stuck in the on the hillside. I happened to be standing by the front door when I saw the headlights coming down the hillside and ran out. And it took a while for him to be able to open the door and get out. He said he wasn't hurt and he did not want me to call for any help, but he did call his wife to come and pick him up. And then the next couple of days, he had to have tow trucks come and have his car towed out because it could not be salvaged the other way. So he knows firsthand how dangerous this road is. And on the north side of Roberts Road, as you're coming up the road, it's just a sheer drop off. And there are portions of the road that have caved in a bit. And so if you're passing a car on Roberts Road, if you're coming uphill, you have to move to the far right to the hillside. If you're going downhill, you can't move because that's the sheer drop off. So there are actually places on the road that if you happen to come upon a car where the shoulder is very precarious, you couldn't do anything if you're on the downhill side. So when we run into construction trucks and some of the delivery trucks that are wider, you either have to back up or the other car or truck has to back down the road. So it's a concern because Mr. Ager's proposal is for 3 homes with, my understanding is 4-bedroom homes. That's a lot of people, and we don't know what age group they would be, but it probably is going to be more than 2 drivers. So that I think adds to the traffic safety issue on Roberts Road that I have, in addition to the well water issue that I think we all share.
Okay, thank you.
Thank you.
Ms. Trover, there we go. You took that. You took care of it. Mr. Welty, you had another.
Yes, I had one more comment about Lad Hill Road. There is no posted speed limit on Lad Hill Road from Main Street in Sherwood all the way to Wilsonville Road. So that automatically, I believe, correct me if I'm wrong here, but I think that puts it at the state maximum, which is 55. A lot of people drive that really fast. A lot of people go over 55. Sometimes there's car rallies that drive through the area. They're not really speeding so much, but line of sight there at Roberts Road and Lad Hill Road is really a big concern because the traffic does sometimes come through there at high speeds. So that's what I wanted to say about that.
Thank you. Bev, I'm sorry, Trover. Ms. Trover, you had your hand raised again? You need to unmute yourself.
Actually, I had my hand raised, Mr. Hearings Officer. It's
William. Okay. I'm sorry.
It's William Rumsey. I failed to mention, but when I gave my testimony about Mr. Drake's property, and I know he was trying to get into this meeting, but probably had some difficulty. And this kind of couples with Leanne Bennett's testimony. So, and I'm sure he'd be willing to put this in writing as well, but his well has dropped over 8 feet since its inception. Mr. Higgins, I believe around 1989. So as Leanne said, a number of wells have dropped. And his property is less than 150 feet from ours.
Okay. Thank you, Mr. Rumsey. Ms. Trover, you still have your hand raised. Did you want to say something else?
Yes. Can you hear me?
Yep.
I forgot to add that Roberts Road is a dead-end road. So there's one way in and one way out. And again, that just adds to all of our concerns regarding if we had to evacuate with trucks coming up, fire trucks or cars coming down, we're kind of trapped. So that adds to the concern of adding even more residents and drivers. Thank you.
Anybody else want to say anything before we go back to staff and the applicant? Okay. Anything further from county staff, Ms. Dance, or other county staff?
Yeah, unfortunately, Johnny Gishel, Transportation Engineering, had to leave. I did want to clarify some points that were brought up through testimonies here today. As far as the hydrogeo assessments provided and peer reviewed, those have a radius area of 1/4 mile surrounding the property. So they are very specific to the property itself, and they take all publicly available record of wells assessed and well deepenings. And then they take that into consideration, and then there's a calculation in numbers that are taken into consideration to assess the availability of water. It doesn't say that no wells will deepen. It says that all publicly available records of wells assesses. And then in addition to that, HGX Solutions took the information provided at the appeal with the additional well deepening you've mentioned several times of 8 feet, in addition to a 1 mile radius, and ran the calculations required in the zoning code related to high groundwater areas, and determined that with that additional information, though not publicly available, that the properties would still be able to support wells. As far as Measure 49 claims and timing, the Rumseys bought the property in 2016. The Measure 49 claim replaced Measure 37 claims that started in 2006 and was adopted in 2009. Measure 49 claims are public record. If the Rumseys had entered the property address of the property they were interested in buying into the state record for Measure 49 claims, the claim would have been clearly evident and available for them to see. Let's see. And then there was questions about the speed limits posted on roads. Engineering's comments provided exhibit, I think 10, address speeds on roads, even if they're not posted. Lad Hill Road speed is 35 miles per hour and Roberts Road speed is 20 miles per hour.
Isn't that the advisory speed on Lad Hill, according to their memo?
Yeah, when speeds on roads, I believe, are based on the class of the road, and the classification of Lad Hill Road has its speed of 35 miles per hour. And then I think they assume 10 miles faster when they do sight distance, and so that assumed speed would be 45 miles an hour, and that's where the sight distance comes into play.
And what's the speed limit on Roberts?
25.
Okay. Thank you. That's what I thought. I thought I heard 20 and it seemed.
Yeah, and it does say 20 some other places, but then 25 is what I'm seeing.
That's what I understood was.
Yeah.
Thank you.
And then there was a question about setbacks. Wells are not required to meet setback standards. They are allowed encroachment into setbacks as long as that well wouldn't be over. And just like you can put a fence on a property boundary, you can put a well in the area as long as you're not building a structure around it. So as long as that structure is under 30 inches in height and not being built around it, a wellhead would be allowed within a setback in the property. Setbacks in the EFU zone are 30 feet from the front, 10 feet from the sides, and 30 feet from the rear for a house. The front setback is measured from the inside edge of the access easement. Let's see. Clarification. I think those are all the items that I wanted to respond to. I did see the information provided by HBH with evidence and roadway improvements. There's a two-paragraph blurb in there that doesn't address the ZDO 1006 standards related to the assessment of all publicly available water information to determine deepenings in available water. And so it's a one paragraph statement. So I'm not sure if that is relevant. It will be taken into consideration for sure, but it doesn't address the code criteria. If there's more information available associated with that, that would be taken into advisement for sure. And then as far as roadway standards and how they're implemented and timing, land use decisions, a partition is a three-step process. The first step is a pre-application meeting that goes over criteria and needs for complete submittal application. And then there's a partition, and then the third step is the recording. There's several things outlined in the decision that need to be completed prior to recording. And so that's where the land use decision that we're looking at today, the conditions of approval and requirements are likely required to be implemented prior to plat recording or listed as conditions of approval on the face of the plat. That is all of my responses.
Thank you. Mr. Eager, do you have anything you want to respond?
No, I think everything has been covered. Thank you.
Okay. Mr. Eager, the appellants have requested I hold the record open. I'm required to do that. I'm assuming you want an additional the opportunity to respond to whatever they submit.
Oh, yes.
Okay. Let me get my calendar.
Yeah, the 150-day timeline is October 10th. And I think that the way we were scheduled, I think we have exactly 5 weeks after this hearing to get to there. So we might need to leave the record open depending on timelines.
I think we're okay.
Okay. If we, so you want to do, so in the conversation of doing, so Ty, you had said you wanted to have, instead of the 1 week, 1 week, 1 week, you wanted to do 2 weeks open record for all new evidence to be submitted. And then it'd be a 1 week rebuttal and then a 1 week applicant only rebuttal. Is that what you were requesting?
I was just going to ask the same thing.
Yeah, that's my suggestion. Just again, given the totality and the new information that I think has come out particularly today, in my experience, that second 7-day period is relatively little used, and then I don't know that this applicant would be inclined to final argument. Of course, he gets that right, but I guess 14.7 and 7 would be my suggestion. Thank you.
Okay.
That, I think that gives, if that gets us to the 26th, that would give you till the 10th for a final decision. Joe, does that work?
I get that as the record closed on the 19th, because
yeah, and then you would have 1 week, 2 weeks, then you'd have 3 weeks.
Yeah, to get before the 150 days. Yes. Mr. Eager, do you want more than a week for the second period in case you want to have your engineer, the groundwater engineer submit something? You don't have to. I just wanted to.
No, I don't need more than a week.
Okay, great. With that, I'm going to close the hearing. I am going to hold the record open as requested by Mr. Wyman for 2 weeks for anybody to submit new testimony and evidence. 26. So I will hold it open until September 5th for anybody to submit. I just got a message on my screen. My internet connection is unstable. So if I disappear, I will come back. Hopefully that won't happen. Anyway, I will hold it open until September 5th for anybody to submit new testimony and evidence. That's 2 weeks. I will hold it open until September 12th for anybody to respond to whatever was submitted during the first 2 weeks. The second period is limited to responses only. No new issues may be raised in the second period. I'll hold it open for a final week until September 19th for the applicant alone to submit a final written argument without any new evidence. The applicant can waive that final argument if they choose to by just submitting an email to that effect. Or you could, if you want to submit a final argument, you can submit it earlier, and I will close it upon receipt of your request to do so. And then I will get my decision out within hopefully roughly 2 weeks. I return from vacation on the 20th, so I will get to it as soon as I get back. But I will definitely get it out before October 10th. I will send my decision to the county. The county will send it to parties of record. What time for the county? Just things have to be received, 4 o'clock. Anything anybody wants to submit has to be physically received by the county by 4 p.m. You can send that to Ms. Dance by letter, by email, snail mail, whatever, hand delivery, as long as it's physically received by 4 p.m. on the relevant date, which again is what?
The 12th.
September. Go ahead, Ms. Dance.
The 5th for new testimony.
Yeah.
The 12th for response only.
Yes, and the 19th final argument.
Mm.
Thank you. So that concludes our hearing, and have a good afternoon, everybody.
Right. Thanks.
Thank you.